My name is Stephan Varga and my research topic is Internet of Data, Fundamental Rights in the context of the IoE and Big Data. As far as the content is concerned, I'll first go over the main research questions. I'll then cover how to balance fundamental rights, some ethical considerations of responsible genomic data sharing, the legal basis for the processing, and various models of genomic data sharing, such as consent, anonymization, and balancing. The main research question is as follows: how can data protection be balanced with other rights and interests in the context of genomic data sharing for research purposes? This also involves some sub-questions. How can conflicts between fundamental rights be resolved, if they can be resolved at all? How can data protection be balanced against other rights and interests? Are the differences in the national implementations of the opening clauses still in line with the harmonization goal of the GDPR? And how do different models of genomic data sharing for research purposes fit into this framework of balancing data protection against other rights and interests? On the balancing of fundamental rights, first off, it should be stated that in recital 4 of the GDPR, it says that the right to the protection of personal data is not an absolute right. It must be considered in relation to its function in society and be balanced against other fundamental rights in accordance with the principle of proportionality. As far as the basis of the research is concerned, I'll build upon the theory of proportionality of Alexei, the writings of Perec on proportionality, and finally Smet on the balancing of fundamental rights. It should be noted that most of the research focuses on balancing one fundamental right against the public interest. In the context of data protection, however, we are mostly concerned about how to balance one fundamental right with another fundamental right. As far as the ethical considerations are concerned, Kalkman and his team identified 4 clusters of common principles in ethical guidelines and recommendations on responsible genomic data sharing. First off, societal benefits and value, the distribution of risks, benefits and burdens, the respect for both the individuals as well as the group, and finally, public trust and engagement. As far as the legal basis is concerned, the main legal basis can be found in Article 9, paragraph 2 GDPR. It does contain consent, letter A, health purposes in both letter H and letter I, as well as research purposes in letter J. Also of note are Article 9, paragraph 4 GDPR, as well as Article 89 GDPR. On models of genomic data sharing, generally speaking, if we're talking about most literature as well as most things happening in practice, there's 2 main approaches. There's either consent or anonymize. Consent, as the name suggests, depends on prior consent being given. Anonymization depends on the data being anonymized. There are, however, some issues with that. First off, as Browns had noted, consent may at times not be sufficient, at other times it may not be necessary. There's also various kind of aspects of consent we could be talking about. There's informed consent, broad consent, dynamic consent, and the new form of data altruism. With regards to anonymization, we also have some issues to deal with. First off, anonymization is not quite as easy as one would originally think. Secondly, we also have a trade-off to consider. The more information we still keep, the easier it usually is to still re-identify the individual. There's also some confusion about the terminology involved. Generally speaking, we can identify 2 main types of privacy attacks. In one, the identification attack, the attacker already possesses partial genomic information and then tries to link additional data with that. In the phenotype inference attack, the attacker knows the identity of the target and tries to reveal additional characteristics about the individual. If we're talking about anonymization, we also have to talk about the data. And here it's important to note that generic data can really mean a lot of things, and most of the time there's also additional information attached to it. Also, we could be talking about some kind of detailed sequence data, only about the metadata, some already analyzed generic data. We could also be talking, if we're talking about generic data, about clinical data associated with generic data, as well as administrative data associated with generic data. As far as legal issues are concerned, SCOPAC, when talking about reasonable expectations of anonymity in the US, identified two main steps when trying to de-anonymize data. First up is the step of individualization, where one tries to get unique data, a quasi-identifier, to try to single out an individual. Once we do have an individual singled out, we can go on to link additional data, where we try to uncover auxiliary information. Of note is that once we've already achieved individuation, identification oftentimes is already implied. What does that mean? It means that the traditional release and forget method of we do have data, we anonymize the data, and forget about the data usually does not work. As Ohm demonstrated in Broken Promises of Privacy, the release and forget model may work at times, though with enough data, it's usually easy enough to break it. There are some answers to that. We could basically try to focus more on the functional anonymization, on the context of data processing, trying to more focus on data access. So we've talked a lot about consent and anonymization, but it should be noted that those two models are not the only ones. In fact, basically they are only a very small part of the large environment. So when we're looking at models of generic data sharing, there's a wide variety of landscapes. We've currently focused on terms and conditions, mainly the consent, as well as what seems to be the general area of technological solutions, but the entire range of possible models of generic data sharing is incredibly broad. One model of generic data sharing we can still talk about is collaborative data sharing. These kind of data sharing, like data commons, often depend on specific exemptions in either the GDPR or the national implementations. As such, these kind of exemptions tend to be based on proportionality and tend to be relatively abstract and broad. They do, however, carry specific risks for the data subjects. In order to apply this kind of proportionality and risk-based approach to generic data sharing for research purposes, we therefore need the balancing of fundamental rights that was already previously mentioned. It should be noted that we lose a bit of legal certainty by depending on these relatively abstract exceptions as well as approaches. One example of one of these more abstract approaches is principle-based regulation, where we're looking at a certain risk associated with an evaluative domain. One last note, the European data strategy is in full swing, and as such it does change the narrative. Not in the sense of changing the underlying characteristics. The new acts usually leave the principles of the GDPR untouched. Thank you very much for your attention.